Hi, everyone. I'm Judy the YouTube Lawyer. Today, Toni Lombardo and I are going to continue reading something from the Charlie Adelson versus Berkshire Life Insurance federal lawsuit. This is a case that Dr. Adelson filed in 2020 because his disability insurance carrier denied his claim for disability insurance benefits. So the case is still going on. And I would like to show you guys the judge who wrote this decision. His name is Judge Rodney Smith. Sounds like a really impressive guy. I saw this post on someone's Facebook page. It says that he's a true native son of the Miami-Dade community. He was raised in Liberty City. His grandparents came from the Bahamas. And it sounds like he had sort of a tough childhood where he was just so happy to get hand-me-down uniforms when he was in the Boy Scouts. And he actually graduated cum laude from Florida A&M. Then he went to Michigan State University for law school, where he also graduated cum laude and worked as an assistant state attorney. Sounds like he was still struggling, where when he was a young attorney, he didn't even have a car, so he took public transportation around, and he became appointed as a federal U.S. District Court judge, I think back in 2019, appointed by Donald Trump. So anyway, just to introduce you to the person who wrote the decision that we're going to take turns reading. And let's welcome Toni to the screen. She's a true crime buff from the Boston area. Thank you, Toni, for being here.
Hi, Judy. Hi, everybody.
Hi, everyone. Well, it looks like we have some people already joining in. Thanks, Malcolm. Yes, let's be enthusiastic about this, right? I mean, I was still thinking, I can't believe on a Friday night we're going to be reading a motion for summary judgment decision. Yay! Are we true crime nerds or what? So,
Yep.
Hey, Five Car and Fancy Fiction, thank you guys for being here. So, let me add that to the screen. Let's see, share this. Would you like to say anything about yourself to the viewers while I'm trying to get this up?
I've been watching Judy forever. I listen to Fancy Fiction, and I'm really into the Dan Markel case. I'm really into it, and I want justice for Dan.
Yes, thank you. Okay, so I'll go ahead and read the first page then. And just to give people some background info, some more background info, a motion for summary judgment is, in lay people's terms, a way to get a slam dunk ruling or a slam dunk win in a lawsuit. It's usually filed by the defense, but either party can make a motion for summary judgment where you're asking the judge to just go ahead and rule in your favor on either the entire case or some specific issue where you feel that the law is already on your side, and based on the evidence and the verified pleadings, affidavits, the discovery that you have, that you should definitely win. So that's basically what you're doing when you make a motion for summary judgment. And in this case, both sides did make such a motion. First, the insurance company made a motion for a summary judgment, trying to throw out the whole case. And then Charlie Adelson's attorney also filed a motion for partial summary judgment. So let's get going. And here we go. So Charles J. Adelson, plaintiff versus Berkshire Life Insurance Company of America, defendant, order denying motions for summary judgment. This cause is before the court on defendant's motion for summary judgment, plaintiff's response, and defendant's reply. Also before the court are plaintiff's motion for partial summary judgment, defendant's response, and plaintiff's reply. This matter arises from plaintiff's claim for partial disability benefits under 3 disability insurance policies issued by defendant. Plaintiff alleges Plaintiff alleges that defendant breached the policies by failing to pay plaintiff's claim for partial disability. Defendant moves for summary judgment on plaintiff's claim, and plaintiff moves for partial summary judgment on defendant's 7th defense, which alleges that plaintiff's alleged loss of income is due to negative publicity resulting from the murder of plaintiff's brother-in-law and the resulting cloud of suspicion surrounding plaintiff. For the reasons that follow, defendant's motion for summary judgment is denied, and plaintiff's motion for partial summary judgment is denied.
Material facts. A. The policies. Defendant, Berkshire Life Insurance Company of America, issued 3 disability income policies to plaintiff, one on October 24, 2006, one on July 24, 2008, and one on September 4, 2008. Jointly, the policies, in parentheses. The policies provide residual disability benefits on a monthly basis to an insured whose sickness or injury requires him to perform the material and substantial duties of his occupation on a reduced basis. Under the terms of the policies, an insured is residually disabled and entitled to a percentage of the monthly benefit after a 3-month elimination period if the insured is at work and not totally disabled under the terms of the policies. But because of sickness or injury, his loss of income is still at least 20% of his prior income. Residual benefits are payable at the end of each month. The insured is residually disabled. The policies also include a medical care requirement, which states, in part, we will not pay benefits under this policy for any period of disability during which you are not under the care of a physician. Such care must be appropriate according to generally accepted medical standards for the condition which is causing the disability and must be provided by a physician whose specialty is appropriate for your sickness or injury. We will waive the medical care requirement during any claim under this policy upon reasonable proof that your sickness or injury no longer requires the regular care of a physician under prevailing medical standards. In order to make a claim under the policies, an insured must give defendants notice of claim within 30 days after any loss which is covered by this policy occurs or starts, or as soon after that is reasonably possible. In addition to a notice of claim, an insured must also provide proof of loss within 90 days after the end of the period for which defendant is liable, or, in quotes, as soon as possible. The court omits citations to the record when a fact is undisputed.
However, defendant is not responsible for paying benefits if proof of loss is delayed for more than 1 year. The policies further state under the heading Proof of Loss, we can require any proof which we consider necessary to establish your current and prior incomes. We have the right to examine all relevant records, including your personal, business, and corporate federal tax returns, as often as we may reasonably require. During claim under this rider, we can require that your accounting practices be the same as those which were in effect at the time you first became disabled. The policies limit the time for bringing a lawsuit based on the policies. No one can bring an action at law or in equity under this policy until 60 days after written proof has been furnished as required by this policy. In no case can an action be brought after the expiration of the applicable statute of limitation from the time written proof of loss is required to be given. B. Background. Plaintiff is a periodontist whose practice consisted of him driving to various dental practices throughout South Florida to perform surgical procedures on patients. Plaintiff claims that he injured his back in January 2016 while in the Philippines, causing him to reduce his work schedule. Prior to his injury, plaintiff says he worked 6 to 7 days a week and 70 to 72 hours per week. Over the years, the dental practices with which plaintiff worked changed for various reasons. After plaintiff hurt his back, he started working less and started, quote, reducing his availability to offices, unquote. In January 2016, after his injury, Plaintiff obtained a prescription for Vicodin, a pain medication, from Dr. Mariana Kaufman, one of the dentists in whose office plaintiff worked. Dr. Kaufman prescribed the pain medication, I guess that's a typo, medication, after plaintiff told her he was in a lot of pain.
On August 29, 2016, plaintiff saw Dr. Jonathan Gottlieb, a board-certified orthopedic surgeon, who prescribed physical therapy for plaintiff's back pain and ordered an MRI on plaintiff's lumbar spine and ordered plaintiff to follow up after the MRI. Plaintiff never returned to Dr. Gottlieb and never did the physical therapy Dr. Gottlieb ordered. On August 30th, 2016, plaintiff saw chiropractor Dr. Eric Friedman for an initial consult and treatment. According to Dr. Friedman's notes, plaintiff was scheduled for 3 visits per week for 4 weeks, at which time a reevaluation will be performed. Plaintiff only saw Dr. Friedman 2 more times after the initial visit because he thought his condition was more serious and needed the attention of someone other than a chiropractor. On September 29, 2016, plaintiff first saw internist Dr. Rahat Fadarani and complained of worsening pain when working, leading to plaintiff cutting back on his work. Dr. Fadarani's notes indicate that he believed that the plaintiff's an injection candidate for lumbar epidural spinal injection, and that it was possible that plaintiff would need surgery in his lumbar spine for pain. Dr. Fadarani recommended that plaintiff reduce his workload to 2 days a week and 5 hours a day. Dr. Fadarani also recommended that plaintiff use a support brace and that the plaintiff consult with a chiropractor to obtain a proper support brace. Plaintiff did not follow these recommendations. He did not receive injections, he did not reduce his workload to the amount recommended, and he did not obtain a support brace from a chiropractor. And the support brace plaintiff obtained he used only intermittently. On October 31, 2016, plaintiff again saw Dr. Fadarani, who again advised the plaintiff to reduce his work hours and limit physically demanding tasks to a level where plaintiff did not experience any more flare-ups. Plaintiff reported to Dr. Fadarani that his back pain had responded minimally to conservative treatments, but he preferred to defer neurosurgical options and steroid injections as a last resort.
C. The murder of plaintiff's brother-in-law. I note that they really should have said former brother-in-law.
Yeah.
Okay. On July 19th, 2014, plaintiff's brother-in-law was murdered. On September 16th, 2016, a 2020 special aired on ABC titled The In-Law and the Outlaws, the Dan Markel murder case, focusing on the murder-for-hire case of Dan Markel, plaintiff's former brother-in-law. Plaintiff was specifically named in the 2020 segment, as well as in several news articles, as one of the people potentially involved in the plot to murder Mr. Markel. After the murder of Mr. Markel in May 2016, one of the dentists with whom plaintiff worked sent plaintiff a letter stating, "I think we have a legitimate interest in knowing the details of what happened in the murder of your sister's ex-husband, since some of the allegations involve you. To be honest, when I asked you about it, I was disappointed with your declining to share, but I understand the need for you to follow your attorney's advice. I have reviewed the matter with my attorney and think it best if we suspend our working relationship for the time being until this whole thing is resolved." May 14, 2016, cool letter. Another dentist plaintiff worked with was harassed by a reporter. A third dentist testified that after he heard about plaintiff's possible connection to the murder, the dentist decided that, quote, "it was best not to contact plaintiff regarding him providing treatment for my patients," unquote, source deposition. Berkshire's representative, John Graff, testified at his deposition that after denying plaintiff's claim, Berkshire did additional investigation, including sending subpoenas to plaintiff's prior employers. According to Graff, none of the responding employers stated that the reason plaintiff was no longer working was due to any type of medical condition, and some indicated that they no longer wanted plaintiff to work in their offices because of the media attention. Graff, however, was unable to name a single employer who had said that.
D. Plaintiff's claim. On October 27, 2016, plaintiff filed a claim for benefits under the policies. On October 28, 2016, Berkshire sent plaintiff a letter and various claim forms to complete. The letter also stated that in order to evaluate plaintiff's claim, Berkshire may require a review of plaintiff's income tax returns or the financial or other business information. On October 31, 2016, Dr. Federani completed an attending physician statement, an APS, in which he stated that plaintiff could sit, stand, walk, and drive for 2 hours each per day, and that plaintiff could lift up to 15 pounds while bending his body. The APS also stated that Dr. Federani had advised plaintiff to reduce his workload and that the need for surgery would depend on plaintiff's progress. According to the APS, plaintiff's next visit to Dr. Federani was set for November 29, 2016. On November 3, 2016, plaintiff called Berkshire and discussed his situation and the claims process with the representative with whom he spoke. Berkshire received plaintiff's completed claim forms on November 21, 2016, including Dr. Federani's APS, plaintiff's disability claimant statement and description of occupation, and authorization to obtain medical and other information attesting to plaintiff's understanding that the authorization was part of his proof of loss of obligations. On November 1, 2016, plaintiff signed his disability claimant statement and description of occupation, in parentheses, claimant statement. In his claimant statement, plaintiff stated that his symptoms began around January 2016, causing him to work in a reduced capacity. Since that time, he got progressively worse. The claimant's statement listed Drs. Friedman and Dr. Federani as treating physicians for plaintiff's back issues and also listed South Florida Imaging as a treatment provider.
The claimant's statement indicated that plaintiff spent 48 hours per week doing surgical work, which included standing, bending over, and twisting to the side, 15 to 20 hours per week doing examinations or consults, which also included bending, and 5 to 7 hours per week reviewing charts or billing. The claimant's statement also reported that plaintiff continued to perform the same duties with a limited capacity. Plaintiff met with Berkshire's field representative on December 13, 2016 to discuss plaintiff's claim. By letter dated December 15, 2016, Berkshire notified plaintiff that it had adjusted the date of disability to August 30, 2016, because that is when plaintiff first sought medical care for his back. The December 15, 2016 letter also stated that additional information was needed regarding plaintiff's occupational duties prior to August 30, 2016, and how plaintiff's occupational duties and volume had changed since. The December 15, 2016 letter requested that plaintiff submit various additional information, including tax returns, pay stubs, monthly profit and loss statements, and copies of monthly CDT code production data showing 100% of plaintiff's work activity for each month from January 1st, 2015 through present. So let's look at footnote 2. CDT is an abbreviation for the Code on Dental Procedure and Nomenclature, which is designated as the national standard for reporting dental services by the federal government. American Dental Association versus Cigna Corp. 2010 case. One of its purposes is to provide a uniform language that accurately describes the dental, surgical, and diagnostic services a dental service provider has rendered. Okay, so getting back up to the paragraph, it says, according to Berkshire's representative, the CDT codes show an insured's work activities prior to disability and to what extent the insured is performing the same duties post-disability. Plaintiff advised Berkshire that he was gathering the requested information and would provide it around the third week of January 2017. On December 27, 2016, Berkshire forwarded plaintiff's available medical records to Dr. David Licht. Dr. Licht concluded that some degree of impairment was supported by the medical evidence, but the prognosis for a return to full functional capacity in time was good.
Dr. Licht further noted that if plaintiff's pain persists, referral to a neurosurgeon, an orthopedic back surgeon, or a pain management and rehabilitation specialist would be expected. On January 12, 2017, plaintiff provided Berkshire with a list of 24 dental offices and addresses where he had worked performing surgical procedures. By letter dated January 23, 2017, Berkshire again requested that plaintiff provide the financial and occupational information it had previously requested on December 15, 2016. On January 31, 2017, plaintiff's agent provided Berkshire with monthly profit and loss statements for Charles Adelson, DMD, PA, and plaintiff's personal and corporate tax returns, including 2013, 2014, and 2015 tax returns for the Adelson Institute for Aesthetics and Implant Dentistry, LLC. He also provided records from a few of the dental offices where plaintiff had worked. On March 7, 2017, plaintiff was again seen by Dr. Federani, who again advised him to reduce his work hours and use a support brace. They discussed neurosurgical options and steroid injections, but plaintiff preferred to defer these options as a last resort. On April 17, 2017, Berkshire forwarded plaintiff's medical records to Dr. C. David Bomar, who is board certified in orthopedic medicine. Based on his review of plaintiff's medical records, Dr. Bomar concluded that plaintiff was not impaired and the records did not support an inability to work full-time. On April 20th, 2017, Berkshire sent plaintiff a letter requesting documentation, in quotes, showing work performed during the period of January 1st, 2015 to present, noting the volume of and duties of your occupation, end quote. The April 20th, 2017 letter also requested copies of profit and loss statements for the Adelson Institute for the period of January 1st, 2016 to present, and a current progress report from plaintiff's physician. Go ahead.
On April 29, 2017, Dr. Bomar completed an addendum to his report, noting that Dr. Federani had not returned his calls. On the same date, Dr. Bomar also sent a letter to Dr. Federani asking Dr. Federani to answer several questions about plaintiff's condition. Number one, what physical exam findings support a need for plaintiff to reduce his work hours? 2, did Dr. Federani believe that the modest MRI findings support a need for reduced work hours? 3, did Dr. Federani recommend any treatment for plaintiff's back pain symptoms? And 4, did Dr. Federani believe that plaintiff's ability to work out doing bench presses was consistent with a claimed inability to perform plaintiff's job as a dentist? By letter dated May 1st, 2017, Berkshire advised plaintiff that Dr. Federani had not responded to Dr. Bomar's questions. It further states that Berkshire was still waiting for the occupational and financial information requested in the April 20th, 2017 letter. On May 2nd, 2017, Berkshire advised plaintiff of the CDT codes and production records it had received, and the 18 dental offices for which Berkshire had either received no codes or unusable codes. Plaintiff did not produce the missing codes. By letter dated June 23, 2017, Berkshire advised plaintiff that based on the available information in its file, plaintiff was not eligible for benefits under the policies. The letter noted that plaintiff had failed to follow Dr. Fadarani's recommended course of treatment, which included physical therapy, steroid shots, and attending a follow-up appointment. The letter questioned whether plaintiff's drop in work was related to negative publicity plaintiff had received when he was named in articles in a television show in relation to the investigation of his brother-in-law's murder-for-hire case. The letter stated, based on the available medical information in our file, your inability to work in a full-time capacity is not supported, and you do not meet the definition of total disability as defined by your policies. Furthermore, the medical records on file do not support restrictions or limitations which would necessitate working in a reduced capacity. Therefore, you do not meet the definition of residual disability. As such, your claim has been denied and your file closed.
Bam. The letter further stated that the decision was based on information currently available to Berkshire, that plaintiff could submit additional information, and that plaintiff had 180 days to appeal the decision. E. Post-denial. By letter dated July 13, 2017, an attorney for plaintiff notified Berkshire of plaintiff's intention to appeal Berkshire's decision and that materials supporting the appeal would be provided. No additional documents or information were provided to Berkshire in support of the appeal. After the denial, plaintiff saw several doctors. Plaintiff saw Dr. Federani on October 31, 2017. Dr. Federani noted that plaintiff was a candidate for injection therapy and reportedly set up an appointment for plaintiff to have injections, but plaintiff did not receive any injections. Plaintiff also saw neurologist Dr. Richard Kishner 3 times after his claim was denied. On January 15, 2018, June 20, 2018, and January 9, 2019. On December 30, 2020, plaintiff filed his single count complaint alleging breach of contract against Berkshire. Berkshire filed its answer and defense. Berkshire's 7th defense states, any alleged loss of income sustained by plaintiff is due to negative publicity resulting from the murder of his brother-in-law and or the resulting cloud of suspicion surrounding him, the plaintiff. Plaintiff moves for summary judgment on this affirmative defense. Defendant moves for summary judgment on plaintiff's claim. 2. Summary judgment standard. Summary judgment is appropriate when the pleadings show that there is no genuine issue as to any material fact and that the moving party is entitled to a judgment as a matter of law. Anderson v. Liberty Lobby Incorporated, HCA Health Services of Georgia Incorporated versus Employers Health Insurance Company. Once the moving party demonstrates the absence of a genuine issue of material fact, the non-moving party must come forward with specific facts showing that there is a genuine issue for trial. Matsushita Elect Indus Company versus Zenith Radio Corporation. The court must view the record and all factual inferences therefrom in the light most favorable to the non-moving party and decide whether, in quotes, the evidence presents a sufficient disagreement to require submission to a jury or whether it is so one-sided that one party must prevail as a matter of law, end quotes. Go ahead.
Allen versus Tyson Foods, quoting Anderson. In opposing a motion for summary judgment, the non-moving party may not solely rely on the pleadings, but must show by affidavits, depositions, answers to interrogatories, and admissions that specific facts exist demonstrating a genuine issue for trial. See Federal Rule of Civil Procedure 56C E. See also Celotex Court versus Catrett, 1986. A mere scintilla of evidence supporting the opposing party's position will not suffice. Instead, there must be a sufficient showing that the jury could reasonably find for that party. Anderson, see also Walker versus Darby, 1990. Number 3, discussion. A, defendant's motion for summary judgment. Berkshire seeks summary judgment based on plaintiff's alleged failure to satisfy all conditions precedent under the policies, as alleged in Berkshire's third defense. Specifically, Berkshire argues that plaintiff violated the policy's proof of loss and legal action provisions. The plaintiff has failed to comply with his continuing obligation to provide proof of loss. Plaintiff failed to comply with the policy's notice of loss provision, and plaintiff's recovery is limited under the policy's medical care requirement. Plaintiff responds that Berkshire cannot obtain summary judgment on unpled defenses relating to post-loss obligations of notice and proof of loss.
Contrary to plaintiff's assertion, Berkshire did put plaintiff on notice of its defense that plaintiff had failed to satisfy all conditions precedent to bringing suit. The Berkshire's third defense states, plaintiff has failed to satisfy all conditions precedent for the payment of benefits under the policies in that, inter alia, A, plaintiff was not under the care of a physician for the entire period for which he is claiming he has been disabled from January 2016 onward. B, plaintiff is capable of performing the material and substantial duties of his occupation as defined by the policies and therefore does not meet the definition of total disability under the policies. And C, plaintiff does not meet the definition of residual disability under the policies because he has not sustained a loss of income of at least 20% of his prior income due to sickness or injury. While the third defense does not specifically mention proof of loss and notice obligations, it raises the issue of conditions precedent. Furthermore, in its answer, Berkshire denied that all conditions precedent had been met and raised the issue of proof of loss during discovery. Thus, plaintiff was on notice of this defense. Accordingly, the court will address each of Berkshire's arguments in turn. I. Conditions precedent. Berkshire moves for summary judgment, arguing that plaintiff's suit is barred because plaintiff failed to comply with conditions precedent to bringing suit. Specifically, Berkshire maintains that plaintiff failed to provide Berkshire with the proof of loss it had requested before he filed suit against Berkshire. Under the policies, Berkshire will not pay benefits if submission of written proof of loss is not made within 1 year of the covered loss. Proof of loss is any proof which Berkshire considers necessary to establish plaintiff's current and prior incomes. Furthermore, plaintiff can only bring suit under the policies 60 days or more after written proof has been furnished as required by the policies. Thus, Berkshire argues that because plaintiff failed to provide proof of loss within 90 days or as soon as reasonably possible and did not provide proof of loss within 1 year, plaintiff failed to meet conditions precedent to suit. Plaintiff responds that he had no obligation to continue provide proof of loss after Berkshire denied his claim, and that he substantially complied with Berkshire's request for information and documents.
Berkshire maintains that under the policies, proof of loss consists not only of the claim forms the insured is required to complete, but also of any additional documents that Berkshire requests, such as the policies state Berkshire can require any proof which we consider necessary to establish your current and prior incomes. Berkshire argues that prior to denial of plaintiff's claim, and despite numerous requests, Berkshire had not received profit and loss statements for the Adelson Institute for 2016 and 2017, usable CDT codes from 18 of the 24 offices where plaintiff claimed he worked, or a response from Dr. Fadarani to Dr. Bomar's questions regarding the status of plaintiff's medical condition, treatment, and ability to work. Thus, Berkshire argues plaintiff failed to timely comply with the proof of loss provision, which is a condition precedent to filing suit. Plaintiff does not dispute that timely compliance with the proof of loss provision is a prerequisite to filing suit. Instead, he argues that he timely responded to Berkshire's request for information and explained to Berkshire that the requested monthly statements from the Adelson Institute did not exist and that he did not have access to the unproduced CDT codes. In Florida, a total failure to comply with policy provisions made a prerequisite to suit under the policy may constitute a breach precluding recovery from the insurer as a matter of law. If, however, the insured cooperates to some degree or provides an explanation for its noncompliance, a fact question is presented for resolution by a jury. Heyman versus Federal Insurance Company, 2001. Here, plaintiff has cooperated to a significant degree, providing the majority of the documents requested by Berkshire, and has provided an explanation for his failure to produce the Adelson Institute statements and certain CDT codes. Thus, under Heyman, a question of fact for the jury exists as to whether plaintiff complied with the conditions precedent to bringing suit. Therefore, summary judgment as to this issue is denied.
II. Compliance with the proof of loss provisions. Berkshire next moves to summary judgment, arguing that plaintiff materially breached the policies by failing to comply with the policies' proof of loss provisions, thereby relieving Berkshire of its duties under the policies. However, as set out in Section 3AI above, because plaintiff partially complied with the proof of loss provisions in the policies and provided an explanation for his noncompliance, there is a genuine issue of material fact as to whether plaintiff materially breached the policies. CID. III. Continuing proof of loss obligations. Berkshire next seeks summary judgment because plaintiff failed to comply with his continuing obligation to prove that monthly losses of income resulted from his residual disability. After Berkshire issued its June 23, 2017 letter denying plaintiff's claim, plaintiff provided no additional documentation supporting his continuing claim of residual disability. Thus, this portion of Berkshire's motion appears to be seeking a limitation on the period for which plaintiff can seek benefits under the policies. Plaintiff responds by arguing that once Berkshire denied his claim, plaintiff had no obligation to continue to provide proof of loss. Plaintiff's argument relies on the Florida Supreme Court's decision in Keel v. Independent Life and Accident Insurance Company, where the court held, the rule seems to have been well settled that when an insurer denies liability during the period prescribed for the presentation of proof of loss on grounds not relating to the proof of loss, which such denial will ordinarily be considered as a waiver of the provisions of the policy requiring the filing of a proof of loss. The reason for the rule is simply that the law will not require the doing of a useless thing. When the insurer denies in advance that it has any liability under the policy coverage, the formal filing of a proof of loss becomes, in the eyes of the law, a useless and unnecessary thing that would accomplish nothing.
Thus, plaintiff argues that it would have been futile to provide proofs of loss after Berkshire's June 23, 2017 letter denied plaintiff's claim based on his medical records and Berkshire's conclusion that he was not residually disabled as defined by the policies. Berkshire responds that the June 23, 2017 letter was not a denial because the letter stated that Berkshire was willing to review any additional documentation that plaintiff believes is relevant to the decision. Berkshire's reliance on Ifergain versus Citizens Property Insurance Corporation, 2017, in support of its argument is misplaced. In Ifergain, the alleged denial letter contained what appeared to be a typographical error, making it unclear whether the letter was a denial. The Ifergain parties continued correspondence after receipt of that letter indicated that the insurer continued to adjust and investigate the claim. Here, on the other hand, the June 23, 2017 letter explicitly states that, quote, your claim has been denied and your file closed, unquote. While the next paragraph of the letter indicates that Berkshire is willing to review additional documentation that plaintiff might submit, the letter indicates that Berkshire has made a determination and will not take any additional action on plaintiff's claim unless plaintiff submits additional documentation. At best, there is a question of fact as to whether Berkshire's June 23, 2017 letter is a denial of plaintiff's claim, and at worst, the letter is a denial of plaintiff's claim. Either way, summary judgment is not appropriate. If the letter is a denial, requiring plaintiff to meet his continuing obligation would be futile. If there is a question of fact as to whether the June 23, 2017 letter is a denial, it cannot be determined whether plaintiff still had a continuing obligation to prove his monthly losses. Accordingly, Berkshire's motion, based on plaintiff's failure to meet his continuing obligation to prove his monthly losses, is denied.
Notice of loss. Berkshire argues that it is entitled to summary judgment because plaintiff failed to comply with the policies, notice of loss provisions which require plaintiff to give Berkshire written notice of claim within 30 days after any loss which is covered by this policy occurs or starts, or as soon as after that as is reasonably possible. Berkshire maintains that plaintiff's disability began on January 2016 when plaintiff injured his back in the Philippines, resulting in plaintiff beginning to turn away work. Plaintiff, however, did not file a claim for benefits until October 27, 2016. Plaintiff responds that his claim's disability date is October 1, 2016, and not January 2016, and that he first received medical advice to reduce his workload on September 29, 2016, which is within 30 days of his claim. Plaintiff further argues that under the policy's medical care requirement, he had no claim until he sought treatment, which he did not do in January 2016. Additionally, plaintiff maintains that Berkshire suffered no prejudice as a result of plaintiff's allegedly late claim because Berkshire relied entirely on plaintiff's medical records and never requested an independent medical examination. The policies state that plaintiff must make his claim within 30 days of any loss which is covered by this policy occurs or starts. However, the policies also state that Berkshire will not pay benefits under this policy for any period of disability during which you are not under the care of a physician whose specialty is appropriate for your sickness or injury. Thus, a loss is not covered by the policies until an insured is under the care of a physician. The policies define physician as a legally qualified physician or surgeon other than the insured who is acting within the scope of his or her license. Therefore, plaintiff was not required to give notice until he was under the care of a physician. Oh, did I miss a footnote?
No, it's right there at the bottom.
Because the policies define physician using the term physician, the court turns to the dictionary for the definition of physician. I think we all know what a physician is.
Yeah, okay. we'll go ahead. Okay. Plaintiff received a prescription for painkillers from a dentist in January 2016. However, because her specialty was not appropriate for plaintiff's back injury, that treatment would not fall within the medical care requirement provision of the policies. Plaintiff saw Dr. Gottlieb, an orthopedic surgeon on August 29, 2016, but was not impressed and never went back. Because the term under the care of is not defined in the policies, it is not clear that plaintiff was ever under the care of Dr. Gottlieb because he only saw plaintiff once. Plaintiff began seeing Dr. Fadarani, an internist, on September 29, 2016, and continued to see him. Dr. Fadarani was the first doctor to advise plaintiff to reduce his workload. Furthermore, plaintiff is not seeking benefits under the policies for any period before October 1st, 2016. Thus, contrary to Berkshire's assertion, plaintiff was not required to give notice within 30 days of his injury in January, because plaintiff's losses were not covered under the policies until he was under the care of a physician for his back injury, and plaintiff was not under the care of a physician for his back injury in January 2016. Consequently, summary judgment in favor of Berkshire is not appropriate on this issue.
Medical care requirement. Finally, Berkshire argues that under the medical care requirement in the policies, Berkshire is precluded from paying benefits for any period of disability for which plaintiff has not been under the care of a physician whose specialty is appropriate for the plaintiff's claimed injury. Berkshire maintains that neither the frequency nor the sufficiency of the medical care plaintiff obtained were appropriate under the terms of policies. Berkshire maintains that plaintiff failed to follow Dr. Fadarani's instructions, did not see Dr. Fadarani on a regular basis, and Dr. Fadarani... Oh, what am I missing here?
Oh, you went ahead. Just keep going if you want to. Yeah, you can skip over that definition of a physician.
Yeah, okay, is that what that is?
Yeah, the footnote.
Okay. Thus, Dr. Friedman was not an appropriate specialist for someone with back pain. Plaintiff responds that Berkshire has failed to provide any medical opinions supporting Berkshire's conclusion that plaintiff's medical treatment was inappropriate. While Berkshire has presented evidence that, if followed, plaintiff's proposed medical treatment was appropriate, Berkshire has not presented any evidence that the limited medical advice that plaintiff followed was inappropriate under the circumstances. Thus, a genuine issue of material facts exists as to whether plaintiff complied with the medical care requirement of the policies. Consequently, Berkshire's motion for summary judgment based on the medical care requirement is denied.
B. Plaintiff's motion for partial summary judgment. Plaintiff seeks summary judgment on Berkshire's seventh defense, which alleges, quote, any alleged loss of income sustained by plaintiff is due to negative publicity resulting from the murder of his brother-in-law and or the resulting cloud of suspicion surrounding plaintiff, unquote. Plaintiff raises three arguments in favor of summary judgment on the seventh defense. 1. The seventh defense is not a true affirmative defense because it does not admit plaintiff's disability, and instead it is an improperly pled allegation of fraud by plaintiff, which was not pled with particularity, as required by Federal Rule of Civil Procedure 9b. Number 2, Berkshire cannot raise, quote, negative publicity, unquote, at trial because it is inadmissible as evidence of financial motive in a breach of contract case. And 3, the negative publicity defense lacks factual support. Berkshire responds that summary judgment on its seventh defense should be denied because 1, it is not an affirmative defense and plaintiff failed to timely strike it. 2, it is not subject to the Rule 9b heightened pleading standard. 3, the evidence does not support plaintiff's claim that his loss of income was caused by his back condition, but rather was due to unrelated factors, including the negative publicity surrounding the murder of plaintiff's brother-in-law. And 4, the probative value of the defense outweighs any potential prejudice to plaintiff. Thus, both parties agree that the seventh defense is not an affirmative defense, as it does not admit plaintiff's disability. You want to go ahead?
Sure. Under the policies to establish that he is residually disabled, Plaintiff must establish that due to sickness or injury, he has lost at least 20% of his income. Berkshire's seventh defense is thus a denial of plaintiff's allegations that he has lost 20% or more of his income because of his back injury and not other reasons. Berkshire does not seek any affirmative relief as a result of the seventh defense. Accordingly, it is not a claim of fraud that requires compliance with the pleading requirements of Rule 9b. Motive evidence. Plaintiff next seeks summary judgment on the seventh defense because motive evidence is inadmissible in a breach of contract action. However, the cases cited by plaintiff do not support its position. First, Aldora Aluminum and Glass Production Incorporated versus Poma Glass and Specialty Windows Incorporated, and Zarella vs. Pac Life Insurance Company. All this is crazy.
Okay. Involved discovery disputes.
Yeah, involved discovery disputes. Second, Aldora actually found that, although motive is not an element of a breach of contract claim, motive evidence was relevant to why the defendant allegedly breached the contract and thus was discoverable. Aldora 2015. Finally, Zarella found that the names of the defendant's other customers were not relevant to the plaintiff's breach of contract claims. 2011. Here, the reason that plaintiff's income dropped is highly relevant to plaintiff's claim. Plaintiff must show that the reason for the drop in his income was due to his back injury, not some other reason or reasons. Thus, other possible reasons for the drop in plaintiff's income are relevant.
3. Lack of factual support. Finally, plaintiff argues that he is entitled to summary judgment on Berkshire's seventh defense because there is no genuine issue of material fact that would permit a reasonable juror to conclude that his loss of income was due to the negative publicity surrounding the murder of plaintiff's brother-in-law. In support, plaintiff cites to the deposition testimony of Berkshire's representative, John Graff, who was unable to name a single dentist that could state that plaintiff's employment relationship was affected by negative publicity. The lack of such negative publicity evidence in Berkshire's claim files, and the lack of evidence indicating that any dentist stopped working with plaintiff as a result of the negative publicity. However, Berkshire has presented evidence of at least 2 dentists who stopped working with plaintiff as a result of the negative publicity. Thus, there is a genuine issue of material fact as to whether the negative publicity surrounding the murder of plaintiff's brother-in-law was the cause or partial cause of plaintiff's reduction in income instead of plaintiff's back injury. Thus, summary judgment is not appropriate on Berkshire's seventh defense. Accordingly, it is ordered that, number 1, defendant's motion for summary judgment is denied. Number 2, plaintiff's motion for partial summary judgment is denied. Done and ordered in Fort Lauderdale, Florida, this 30th day of August 2022. Rodney Smith, United States District Judge. Okay, so there we go. What do you think?
Denied. No money for Charlie.
Yeah, I think that the insurance company is definitely going to be able to show that he did not experience that drop in income due to his back injury.
I think the reason he was just a lazy bum who didn't want to work and he just wanted to collect people, collect.
Yeah, that's basically what he said in his phone call with his mom that was wiretapped.
And she's so proud of him.
Mm-hmm. Yeah, because he just wanted to enjoy life and, just screw around, have fun on his boat and his go-karts and just enjoy life as he knew it in case
his drugs
shortly. Yeah. So, at least Charlie managed to travel around and enjoy his life for a couple of years before he got arrested, right?
Yeah, he must really, really be missing the Florida sunshine.
Yeah,
and all of his toys and his women.
Yeah, that's why he looked so sickly. Like he did not have his vitamin D. Yeah. Sorry, Charlie, says Gina. Yeah,
I just try to picture Donna because Donna watches the hearings on TV.
Yeah, I'm sure they do. Yeah.
Seeing her poor baby.
Yeah. Although I don't know, I mean, she does seem to have a lot of anxiety and probably a lot of like, I don't know, panic attacks maybe.
I'm sure she does.
Yeah, so maybe she can't even bear to watch it live. She probably has to have someone just like summarize it for her later on.
I'm guessing family life isn't too wonderful for any of them anymore.
Yeah, it's got to be really nerve-wracking not knowing if you're going to get arrested or if you're being bugged. Like
Yeah.
every computer, every phone, every place you go has some sort of wiretap maybe, or you just don't know if like people who used to be your friends are now turning against you and telling things to others.
I'm sure they barely leave their home now.
Yeah, probably. Yeah, True Lifestyles. Thanks for being here. Says Charlie needs to take a Xanax like he did on a flight from Manila to LA. Maybe he'll feel better about his life. Yeah. Well, he does still have the right to get his medications while he's in jail. But
Xanax? Really?
yeah, probably because, people in jail still need to take medications if they really need it. Although, as True Lifestyles probably can tell us, I don't think his intake forms indicated anything about psychiatric problems or
Yeah, I
and
don't think there are no Xanax in Leon County. Just like
okay.
I don't know.
Yeah. Well, but although I kind of feel like if the person medically needs it, maybe. Oh, okay. Well, I guess people are saying you're
Yeah.
right. No Xanax in Leon County Jail. Really? What if the person needed it medically and already had a prescription? Just like if you're diabetic, they can't deny you your medicine.
Yeah, I take a thyroid pill every day.
Oh, okay.
Yeah.
Yeah, but if you went to jail, I mean,
I
I
would
would
get
think
my
that.
thyroid pill, god damn it.
Yeah, I think you're still entitled to your thyroid pill if you
But
really
that's
need.
different than Xanax. Xanax is like a feel good pill, and they don't want the inmates feeling good. They want.
Oh, okay. Well, yeah, I don't know what the policies are. Yeah. The decision to kill Dan has destroyed their lives. I bet they regret it. Very stupid decision. Yeah. This cervical is a disability. I'm out now since 2019, had 3 surgeries, still need more. I'm not defending him at all. Believe me, if he had issues, he would know it. Yeah, and maybe he would have tried the injections or whatever other things the doctor had recommended. Oh, they only have Valium to help the alcoholics wean off and not have a seizure. Oh,
Oh.
okay. Well, here Rochelle is saying you can get Xanax in jail. Sarah says they will give Trazodone. Okay. Yeah, I have no idea. I have no idea. I'm sorry. I'm not the expert on what medications or drugs you're allowed to get in jail. Yeah. Charlie didn't lose this summary judgment. He was going to get something. That's why the insurance company settled, I think. Oh, okay. Well, this not in this case. It was the other lawsuit because, believe it or not, he had a different lawsuit involving a different insurance company called Standard Insurance. So
Yeah.
that was the one that settled about a year or so ago. Yeah. So and it was confidential, so we have no idea, what the settlement terms were. Yeah. He should have just chopped off a finger. Okay. He needs a boatload. Okay. Yeah, that was funny. Massage in the grotto. That was so funny. Did you hear that? Just the way he
Yeah.
talks is just so smug and annoying. Oh, yeah. Okay. So let's see here. Okay.
Yeah, he liked telling people of all his escapades. He really liked to brag.
Yeah, yeah, just always talking and talking and, look where that got him. Yeah. Okay, so we're all looking forward to seeing Fancy Fiction and Karen Cyphers when the show comes out on Surviving the Survivor, which is another YouTube channel that's covering the Dan Markel a lot. Dan Markel case. Yeah. So looking forward to that. Did Chuck get paid? Yeah, not in this case, we don't know yet because it's supposed to move ahead for trial, but there's no actual trial date set yet. They know the type of family he comes from, the suing type. Plaintiff has been scheming to scam disability insurance for years as part of his retirement plan. Yeah, it sounded like in one of Fancy Fiction's more recent phone call videos, it sounded like he was even joking about it with his CPA. That call with Jay Shapiro, where I think Shapiro made some kind of joking reference to something about disability insurance. Do you recall that, Toni?
No, I don't, but I was just thinking of something funny. You know that that YouTube channel that Donna had with Javi kissing the giraffe?
Yeah.
Well, I had commented on that. And I wrote something like, those were the good old days. And someone else commented as Charlie and said, I'm so sorry, Mom, for messing up. Blah, 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 blah. I
Yeah.
know that you just got to go read it. It was.
Yeah, I did. I saw
Oh,
those
you did?
comments. Yeah, yeah. It was definitely like really funny seeing
It
some
was a
people.
riot.
Yeah, I see. Yeah, it's funny that she's still leaving that video up. Maybe she forgot that
Right?
she had that YouTube channel herself.
Well, she must be getting notifications or something that she's got comments. I know she
Yeah,
has.
that's true. But then again, sometimes people set up their YouTube accounts ages ago with some old email, so they never
Yeah,
see any follow-up comments. Yeah.
that's true.
He probably won't be in general population before the trial, even if he wants to, because of the large amount of publicity. It's a liability for the Leon County Jail. Oh,
He's too much of a wimp. He'll want to stay right where he is.
oh yeah, yeah. He doesn't want to be with the rest of the prisoners. Yeah.
No.
About time someone walked all over Chuck. He uses and abused everyone in his reach. Wendy Suit is going to make a third appearance. Well, it could be. She seems to really like that dress. Yeah. Yeah. Thank you, Gina, for your kind words. Yeah, that's right. Fancy fiction, as well as true lifestyles, have been covering this. That apparently Charlie admitted in that Matsuri recorded recording at the restaurant that it was his fault. He said it was my fault. He had some woman in Vietnam asked her to walk right on his spine, and that's when he really hurt himself. Yeah.
My brother
Um,
used to make me do that to him.
oh, did you ever actually like accidentally like hurt his back?
No, because I was only 9 years old and weighed like 80 pounds. So
Oh, okay. Yeah. Do not have some unlicensed person, stomping all over your back. Yeah. Okay, buy yourself a Barca lounger too, so you're comfy for a 3-week trial. Yeah, I can totally imagine it being a 3-week trial. That's basically what Kappelman said, that 2 weeks was a little too short for the Magbanua trial.
I
So,
can't wait.
yeah, I don't think he's going to get any sort of settlement. Yeah. So, good luck to Wendy Furman in that lawsuit regarding disability benefits. Yeah. Watch Wendy come back in the same dress. Yeah. Oh, okay. She said something made you laugh. Yeah, was that the thing about the Vietnamese lady of the night that stomped on his back?
Yes.
God. Oh my gosh. Yeah. Hi, Laser Wolf. Got to stock up on beer and pizza for Charlie's trial. Yeah. I'm actually, thinking about flying or even driving down to Florida for that
Oh, I
because,
wish I could.
yeah. Yeah. Well, maybe you can. We don't even know when it's going to be. It could be as late as May. Now they're
Right.
talking about anytime from late February or maybe even April or May. You got to take a break for spring break. So,
I
yeah.
got some vacation time coming. I can hold on to it.
Yeah. Yeah, exactly. I mean, Florida is a fun place to visit, and it's not going to be too hot if it's February or March. Although
Right.
sometimes it gets really hot in April, even.
Yep.
Yeah. I remembered a comment he made about his insurance claim, almost like he referred to it as his bread and butter.
Yeah, I
Yeah,
remember
it
that.
was like his retirement plan. Like he already had a plan in the works, because he's already slowing down his work. He wants to enjoy life after finding out that his friend was dying of pancreatic cancer. Yeah.
He
Oh,
never
yeah,
lived.
the name of the channel changed. Yes, I posted a community post about that because my channel name was showing up only as Asian American Leg if people were watching on a cell phone, because it had too many letters in it. And obviously, I am not just focusing on Asian American news or Asian stuff. So I figured I need to broaden the appeal with a slightly different name. Okay. Yeah. So it is going to go forward for trial, but there is no actual date scheduled now. And I'm pretty sure Five Cars said that there's supposed to be another case status phone conference around maybe November 29th. In this case, the Berkshire Life Insurance disability case.
Charlie will be in court again in December for a update hearing or whatever they call it.
Oh, yeah,
Status.
in his criminal case. Yeah, that's
Yeah.
in December. Yeah. So,
His first Christmas in jail.
oh, well, I'm sure his family can buy him all the care packages that he wants. So long way from Vancouver. Okay, we'll be in line. Okay. Oh, by the way, so it's already after 8. So didn't you say that Fancy Fiction was doing her own live stream at 8 o'clock?
She was. I don't know if she's going to.
Okay.
Fancy.
Well, no, it's already over an hour, so I don't want to, take away an audience from the same group of people that would also be interested. Oh yeah, right. As if I don't think Charlie has YouTube access now. Yeah.
Oh, we wish he did, though, don't we?
Yeah, that would be funny. But then he'll be coming after us and looking for hitmen, right? Cameras in the courtroom. Well, I'm sure there's going to be cameras in his criminal case, but in terms of the federal disability case, I doubt it. I don't think they usually put this out, to the
Fancy
media.
moved her chat till 8:30.
Oh, okay. So we'll stay on for maybe like 5 more minutes or so. Yeah. But I already feel like my voice is giving out again. Gosh, so much for this throat soothing tea that I think it was Terry or somebody recommended. Yeah. How are you feeling? Does your throat hurt after reading so much?
No, my throat don't hurt.
Really?
No.
Well, you have a good voice for broadcast then.
I wish.
So what are the other cases that you've been looking into?
Oh, the Scott Nelson trial. I just whizzed through the whole trial in like a day.
Oh, what was that about?
Deep Dive has it posted. He's a homeless man in Florida who was tired of being treated, bad by the system and the government. So he decided he was going to get even by going after, people in Winter Park, Florida, because they have money. So he kidnapped a woman and killed her and got caught. And I just watched the whole trial.
Oh my gosh. Wait, was that the thing that Mentor Lawyer had been focusing on recently?
Yeah, he just recently posted the police interview.
Oh, okay.
And
Okay, yeah.
that's
Yeah,
what,
I haven't even had time to look into that, but he did give a quick summary at the end of one of his live streams where he was like, yeah, this is just a horrible, terrible case where he just like kidnapped some young woman.
she was 56. She was a nanny, and he just pushed open the door and tied her up. And during his police interview, he was telling the police that he didn't really feel bad about it, and he wished he could have killed more people, and he's just crazy.
Oh my god.
Oh, and he took the stand in his trial too. So yeah.
Okay. Well, that's very interesting. Yeah, that's another thing to look into. So hopefully we'll be able to do another live stream focusing on all these like other crazy cases like the David Trons. Is that how you pronounce it?
Yep, he's going to be doing court again in January. He looks like a caveman now. He let his hair grow down to his bum almost, and he's got a beard down to his boobs almost.
Yeah, he looks like some crazy, insane,
he looks
mentally ill. But see, that was probably part of his whole shtick, because he was trying to avoid trial by saying that he was mentally ill, and there was a psychiatrist that diagnosed him as schizo, right?
Yeah, but now that he's fine, they said he's fine for trial now, so he should be moving along on that.
Yeah.
The Rodin trial that's going on right now, there's just so many different characters. It's just so hard to follow that.
Yeah, exactly. Even when reading news articles, they keep referring to all these different names. I'm like, who's this? Is this another relative? Or
you literally have to take notes during the trial.
Yeah, you need to like draw this gigantic like web connecting like who's this and what side of the family or whatever. So yeah. Okay, well, I think I might as well go ahead and wrap it up so we can take a break. And I'm kind of tired of sitting here in one position the whole time too. And I want to get ready to enjoy Fancy Fiction's live stream also.
Okay, me too.
Thank you so much, Toni. We'll be in touch then.
Yes, we will.
Okay, thank you guys for watching. And
bye, everybody.
We'll see you on Fancy Fiction's channel soon. Have a good weekend.
Bye.
Oh, and actually, I'm going to be back again tomorrow. It never ends, right?
What are you doing tomorrow?
So tomorrow at, I'm pretty sure 5 o'clock Eastern time, True Lifestyles and I are going to be reading an absolutely hilarious, scathing review of Wendy Adelson's book. This is our story. And I'm also going to be live taste testing those potato chips that are exclusive to jails. It's called the whole shebang. I finally ordered some. It was very expensive, but Anyway, so I'll do that real quickly because there were some people that were really disgusted when I was eating on camera.
Oh, only a couple. We thought it was adorable.
Yeah. Yeah, thank you, True Lifestyles. I can't wait it's going to be really entertaining, even if you've already read that review before, but I think it'll be interesting. So thank you. Okay, we'll see you guys on Fancy Fiction's live stream soon.
Okay, see you
Thank you.
later.
Take care. Bye.
Bye.